Hey folks, right now so many Americans, especially on the left, are turning to the courts to stop this regime's abuses. Gotta look somewhere. Congress certainly isn't helping out. So, filing lawsuits, citing constitutional rights, hoping judges will step in and stop what looks like, well, what is an authoritarian government on the move. But I want you to understand something, just your resistance history dispatch of the day. That instinct to treat the judiciary as the last firewall against tyranny is not only modern, it might be unproductive. It might even be dangerous. Because as we've talked about before, the Constitution was not built to protect your liberty. It was built to consolidate federal power. And the men who drafted it, the ultranationalists and nationalists who dominated Philadelphia in 1787, and whom this regime loves, were trying to be federal authority. They didn't design checks against themselves. Why would they? They thought they were fine people. But let's talk specifically about the Constitution and the courts. In Philadelphia in 1787, they didn't design the courts to defend liberty. Article 3 was built to resolve disputes that would threaten the new federal order, things like conflicts between states, cases involving foreign officials, admiralty and maritime suits, cases of original jurisdiction, and suits between citizens of different states. It was a legal backstop for federal supremacy, not a rights-enforcing mechanism. The goal wasn't to protect people from government power. It was to protect the government from what they saw as the potential sources of disorder. There was no expectation that courts would restrain government power. Not even a tradition of it. So we can let them off the hook for a moment, just for this moment, for missing judicial intervention on behalf of liberty. Why? Because the only constitutional tradition the framers had came from Britain. And in the British system, well, mostly the English legal legacy, let's be precise, the Scottish legal legacy has somewhat different implications. In the English legal legacy, courts didn't strike down laws. And that applied to the way it evolved in the American colonies. But they couldn't. That power belonged to Parliament, to the Crown, to the makers of law, who were its first and last interpreters of it. Almost by definition, after 1688 at least, what King and Parliament, or King and Council, or just Parliament, forget about kings and queens, did, was, and more or less still is, constitutional by definition. So let's take some of the most famous liberty cases in 18th century England and have a lot of implications for what's going on in the Revolutionary period. Somerset versus Stuart, Entick versus Carrington, part of the John Wilkes cases. If you want to know 18th century politics, be prepared for a hefty dose of the odious John Wilkes. But those cases, although involving fundamental questions of liberty, were all decided on common law grounds, even if they dealt with habeas corpus, even if they dealt with things about general warrants. They were judged on common law grounds, not constitutional ones, almost procedural ones. So they weren't considered constitutional issues, because that wasn't the court's job. Even William Blackstone, the legal Bible for the 18th century and beyond, didn't talk about judicial review. Parliamentary sovereignty, sure. And habeas corpus, absolutely. But enforced by the courts, not as a constitutional right. And when they finished writing the Constitution and it was sent to the states for ratification, as we've talked about, there was no Bill of Rights, no declaration to outline the rights and liberties of the people that the new government could not invade, and therefore not for the Article 3 federal judiciary to even think about. It was a document, yes, people throw out the preamble in the name of the people, but the people stopped at the end of that third word. We the people. And that wasn't an oversight. That was a choice. They talked about it. They debated it. Even a few delegates to the Constitutional Convention wouldn't sign the Constitution because it didn't have a Bill of Rights. And still, they rejected it. The nationalists, such as James Madison, said the federal government only had the powers it was given, so it didn't need specific limits. That would be dangerous in and of itself. The ultranationalists, like Alexander Hamilton, they didn't care. But there were people who did care, and they did care very much. And those were the Constitution's opponents. We call them anti-federalists. That term came in much, much later in the discussion, much later in the ratification process, and only in New York. Don't get me started about that. But the Constitution's opponents, many of whom had been drivers of the revolutionary resistance movement of the 1760s and 1770s, which spent a lot of time talking and writing and fighting over those rights. No taxation without representation, opposition to standing armies. They had to battle for them across a bruising ratification process. And by the way, didn't get those two things. But the opposition did win, sort of. The Bill of Rights is there. Go take a look at it. But that's a whole nother story, and it's part of my book. But even after the first 10 amendments were adopted, no one expected the courts to enforce them, not the way that we consider it today. So when John Adams, for example, signed the Alien and Sedition Acts, literally criminalizing dissent, no one ran to the courts. They didn't even think about it. So Jefferson and Madison, they turned to the states, not the judiciary, because that's where they believed opposition rested. That was clearly laid out during the ratification debates, especially by the nationalists. You want protection of individual liberties? That's what the states are for. Even Hamilton, who wrote once that courts could theoretically have a role in checking federal power, Federalist 78, he punted the protection of liberties to the states, most of which, but not all, did have declarations of rights as a part of their constitutions. South Carolina wouldn't put it in a Declaration of Rights because most declarations of rights included a reference to all men are born free and equal. And they thought that it would be a little rich for them to put that into their constitution, given that more than half of the people of South Carolina were enslaved by the other less than half. Federal judicial review didn't fully appear until Marbury versus Madison in 1803, and even then John Marshall used it not to protect liberty, but to define the court's institutional power, and he did it very gingerly, very tenuously, because he knew he was establishing original grounds. This was an innovation, a uniquely American concept. And then 30 years later, in his last opinion, John Marshall reinforced the opinion about how the Bill of Rights applied to the states. It didn't. In that opinion, he specifically said that the rights amendments to the Constitution did not apply to state action at all. And when the courts finally did use a rights amendment to strike down a law, Dred Scott in 1857, a perverse reading of the Fifth Amendment, used to strike down liberty and uphold slavery, although relying on the Due Process Clause. The idea that courts are the natural, even effective defenders of liberty only really began after the 14th Amendment. The 14th Amendment is the revolutionary amendment establishing the Second Republic. That's the linchpin. And even then, it took more than 50 years for that to take shape, to really be put into effect. Not until the 1920s, when the courts turned around and through incorporation, selective incorporation, started to apply the Bill of Rights to the states through the Due Process Clause of the 14th Amendment. So when the Warren Court and the Burger Courts expansion of the application of the rights amendments in the 1950s and 1960s and 1970s, they didn't lead, they followed. Civil rights, due process, bodily autonomy, marriage equality, all of it came under pressure from people, from movements, from risk, and resistance. That's what turned federal courtrooms into battlegrounds. But it was never neutral ground. It had to be taken. And that's where we're losing again. Because this regime isn't dismantling the courts. Not yet. It's daring them. Flooding them with executive actions. Delaying, defying, but also overwhelming. Dockets aren't built for this. And it knows, just like the original nationalists did in Philadelphia, that the courts were never really meant to stand in the way. The belief in judicial protection of rights is a constitutional improvisation. And like all improvisations, it's original, it's innovative, and it's not permanent. Other countries now have constitutional courts that are created intentionally to do that kind of thing. The United States didn't, the United States doesn't. It is judge-made law. So the courtroom is not sacred any more than the Constitution is. And it's not safe any more than the Constitution is. But it has been a place where liberty was defended when enough people forced it to be, using not the Constitution itself, but using the Bill of Rights, the product of the resistors to the Constitution. And that space is shrinking again, right now, as we speak. We need to remember what it took to make it a battlefield in the first place, because the fight to defend liberties never started in the courts. And damn it, it's not going to end there either.